that background, and in light of sentiments, is some in public, many in private, which seek to either misrepresent, block, or create tensions and so forth, there has been a built-in strategy to try and bring this matter to the public through a court process, which would demonstrate the seriousness of the issues, hopefully help structure the discussion and content, but more importantly, bring clarity to the fundamental question of what is a term limit provision versus other things, including things like term of offices and so forth. There is a very serious, I would say, misunderstanding, some might say confusion about what a term limit provision is. And people are using that confusion or misunderstanding to generate or try and create political mileage in ways that are destructive, ways that are meaningful, and ways that, if left unattended, and people or the cabinet or parliament begin the process of giving effect to that resolution, there could be disaster purely because of what really is genuinely opportunistic misrepresentation or genuine misunderstanding of what a term limit provision is. And so there is an intention to trigger, especially now in light of 𝗞𝗜𝗟𝗟𝗘𝗗, but also what's going on, including what has happened today, so on, and all these things, that if these things are not done properly, we can generate problems in the country. So there's an intention to trigger an application from a credible organization, not a tortoise applicant, but an applicant with a real and substantial interest in this matter, who should approach the Concord seeking direct access in terms of Section 85(1), alleging that their rights in terms of 56(1), maybe 67, and so forth, are likely to be infringed by the now clear actions of the ruling party and government to pursue their resolution. And that if that can be possible, then it will give an opportunity to respond, because the respondents will be the party and the Minister of Justice in particular, but there will be other three, to really make a strong case that this can't infringe on any rights because it's constitutional, and in any case the resolution will not, it does not seek to change or amend any term limit provision. It seeks to amend provisions which are permissible to amend without offending term limits and so forth, and make it a very strong case. And it does appear there is really a strong case to do so. And however, because it is predictable that if this is not done now, there will be a lot of confusion in the period leading to the implementation before Parliament in Cabinet, when the bill is being considered. There will be lots of confusion and all that. The parliamentary process, even more confusion. Then if the legal actions come later upon the enactment of the amendments, then there will really be fireworks. And it will be very difficult to have a meaningful even litigation to be politicized, and heaven knows what will then happen. So rather than wait then, until then, the day is to do it now. Fortuitously, Counsel Stolle is the well-known lawyer for 𝗝𝗢𝗡𝗦𝗢𝗢𝗢𝗢𝗓, who genuinely feel that this resolution will infringe on their fundamental rights, and have been outspoken, including today. The thinking is give them an opportunity, a real opportunity to pursue the matter. There may be a need to fine-tune the course of action and so forth to demonstrate whether they have a substantial interest and there is a real and substantial dispute here, that it is not an abstract application asking the court to interpret something, but that there is a dispute that can be demonstrated. If that is possible, then the party and the Ministry of Justice will have an opportunity to respond in a manner whose outcome would be to clarify whether in particular sections 95 subsection 2b and 143 subsection 1 are term limit provisions. And that, if this is a reasonable plan in broad terms, the devil is always in the detail, then the best advocate to represent the party and the minister as the main respondents would be advocate the number one and advocate Professor Matuku number two, for the simple reason that as far as advocate is concerned, not only is he a respected advocate, but also, like Professor Matuku, were the lead advocates who represented the Mupungu in that case, which is the only case which fortunately came before the Constitutional Court that has dealt with the question of what a term limit provision is, and would therefore be the best to represent the party, and the minister is the main respondent. This argument, or this point, which is an obvious point, that advocate really would be the best have made myself. I am there, and of course I'm talking to legal people, and I'm sure I'm protected. That what I'm saying just to you gentlemen. But I'm